Good evening, everyone, and welcome to another edition of our Justice and Pieces guest speaker series, where we've been talking with everyone around the legal profession and even some outside of the legal profession about everything that there is. And today we are joined by Anita. Anita, first of all, thank you so much for taking the time to speak with us, and maybe you can give us a little bit about your background.
Thank you, JP, for having me on your show. I'm really so happy to be here. Like I've said, I'm a huge fan of yours and the programs. And as you know, I probably watched more of the Bencher episodes than maybe anybody else. I was really interested in that. So I'm grateful to you for all the work you've done with that and with this series. So it's a real honor to be here. As for me, I am, one of the oldest women in criminal defense left standing, and we will talk a little bit about those statistics. But I celebrated 30 years at the bar last fall. So I was called in 1992. I graduated from the U of T Law School in 1990, which at the time still had some of the same professors it has now, but I paid $1,300 for tuition as opposed to the 40,000 people are paying for the same professors in the same place now. For most of my career, except at the very beginning, I have practiced something I like to call mental health justice. It's a very niche area, and basically at the center of the controversy for every case that I do is someone with a serious mental health issue. But I practice in a lot of different forums, civil mental health law, involuntary committal tribunal hearings. I do a lot of administrative tribunal proceedings where I represent people in crisis, and criminal law where I represent people who are unfit or not criminally responsible. I do a lot of appeals. I have about 225 appeals in the Court of Appeal under my belt. That's a big number. I do some litigation in the Supreme Court of Canada, fairly significant number. And I really love doing coroner's inquests. So every year I'll take a couple of months out of my practice to get involved in a coroner's inquest where mental health is again at the center of the controversy. So that's mostly, unfortunately, police killings of people in crisis, often Black people in crisis, as we know, or institutional deaths of people who are dying within hospitals. So I hope that's the kind of background you meant. That's what I do. Personal background, I was born in Hungary. I was a refugee. I'm an immigrant. I'm Jewish. My husband's from Pakistan. I have two wonderful mixed race children and a disabled gecko.
Perfect. So, Anita, so a lot there to go with. So maybe let's start kind of and it's great because I'm teaching criminal law and tribunals. So I mean, there's like two big areas there we can touch on. So let's start with the criminal practice. And you mentioned, in terms of fitness and people may not know like NCR and the whole process there. It's not really even in a criminal course, not really covered extensively, right? So maybe you can give us, I know there was the CLA conference last week. You were a panelist there with Maya and I remember the other, but you could give us maybe a quick overview, of kind of what's involved with the mental health and the cross section in terms of fitness in a criminal defense.
Sure. So one of the reasons we spoke on this topic and had a little panel at the spring conference for the Criminal Lawyers Association is that it's an area that a lot of people are not familiar with, but in the course of any criminal proceeding, it could happen anytime. So you could have a client who's not fit to defend their charges at any time, at the beginning of the process, at the bail end of the process, throughout the trial process, and at any time they could become not fit. And in fact, even after the verdict, before sentencing, they could become unfit. Some people say they can become unfit after that when there is the appeal stage. So what does it mean to be unfit? Well, right now we've got new case out of the Court of Appeal that we talked about endlessly at the conference, but I won't bore you with that. The bottom line is just if you have a person accused who is facing a criminal charge, are they going to be able to be present for their trial in a meaningful way and participate in their defense and mount a defense in a meaningful way? So, one of the basic tenets of our criminal law is we don't hold criminal trials. We don't have the criminal process go on if the accused person is not physically present, right? So if they can't be there, if they're sick, they're in a coma, they're in the hospital, the process of it can't continue because they have to be present for their trial. So the idea is the same thing with fitness, except there has to be a mental disorder. So, and it has to be because of mental disorder that the person is not fit. So if you have someone with a serious mental disorder who, as a result of that, is not able to participate meaningfully in the proceedings, they don't understand the nature of the proceedings, what they're charged with, or how they would plead. They don't understand the participants in the justice system, what the role of the judges or Crown versus defense. They don't understand what an oath is or what perjury might be. And that's one part of it. And the second part of it is if they're not able to communicate with counsel. And are they able to tell their lawyer what happened in order for their lawyer to assist them with the defense? But now we must also ask, are they able to make the really important decisions that only the accused can make during a criminal trial about strategy in terms of the defense that they want to go with and whether or not they want to testify and whether or not they're going to plead guilty. So that's really the bottom line. And if there are concerns about fitness, the lawyer for the accused can raise the issue in some circumstances. The Crown can raise the issue. The court can raise the issue. And a fitness assessment is then ordered, a forensic psychiatric assessment. Somebody decides if you're fit or not fit. If there's a court finding that the accused is unfit to stand trial, the criminal process halts, completely stops, unless and until that person becomes fit. And there are mechanisms to try to get them fit. You can get one of these things called a treatment order. It's a big deal because nowhere else in the law can you administer powerful psychiatric medications to someone who may otherwise be capable to make that decision if but for the criminal charge and the unfitness. And if it's likely they're going to become fit with that forced treatment, you have 60 days to try and get them fit. Society's interest is in getting people fit to stand trial so that they can go through and face their criminal charges and have those charges resolved. So that's in a nutshell. If they're unfit for longer than that, they go away into another system, into the Criminal Code Review Board system. They're remanded there, and then they can potentially be there forever if they're permanently unfit.
Now, Anita, one of the things that comes up typically, in the news, they'll say, "Oh, someone did some crime, and then they're not fit or not criminally responsible, and they're just gonna walk away." Then, years later, now they got access, they've done better, and people feel that justice hasn't been served because somebody might have been injured or killed, and the person now is out of the the criminal system and all sorts of things like that, where they feel what's going on here, right? Or some even say, well, are they even really suffering from the things that they're saying? So this is just kind of an excuse, and our system is soft on crime, all sorts of things I'm sure you've heard over the years. So maybe you can explain kind of that, you're mentioning that path there of it may be permanent, how all that works, and why that in fact is not true.
That's a really great question, JP. So NCR, or not criminally responsible, is different from unfit. It's similar, but it's not through the criminal process or the criminal justice proceedings. It's at the moment of committing the offense. So the question is, did you have criminal responsibility? Were you really responsible for the offense when you committed it? So it's a snapshot test of your mental capacity at that time to understand the nature of the offense and the consequences and whether what you did was wrong, and in particular, morally wrong. So if someone finds that you lacked one of these things, you either didn't know what you were doing, didn't understand the consequences, or you didn't appreciate that what you did was morally wrong as a result of mental disorder, then you're found NCR, or not criminally responsible. And you're quite right. Popular sentiment, every time something like this happens in a high profile case, there has been a murder, somebody's dead, or several people are dead. One of the most high profile cases is Matthew DeGroot out in Alberta, who shot and killed 5 people at a frat party, 5 young people in their early 20s. And so these cases, the beheading on the Greyhound bus, these cases are super sensationalized, and the public comes to believe that people are getting away with murder, literally getting away with murder, when they get an NCR verdict instead of a guilty verdict, because they don't go to prison for the rest of their lives. And so people think that instead what happens, it's like an acquittal, you're innocent, you walk free, and you got away with it. It's a get out of jail free card. And that is not the case. So quite the opposite is the case. When people are found NCR, they go into the Ontario Review Board system in Ontario, but there's a criminal code review board in every province and territory. And for these serious offenses, you immediately go into a maximum secure facility. So in Ontario, you would go to Waypoint, which is a high secure or maximum secure psychiatric facility. And it's quite prison-like. So people, it's just like jail or prison in many ways. And then it takes many, many years for most people to sort of cascade through the system, where restrictions on their liberties are slowly decreased as they get treatment and their risk is diminished. So people can be in the system. On average, most people spend more than 10 years in psychiatric detention or supervision under the review board. And some people spend 30 or 40 years, and a lot of people will die indefinitely detained. There are people who came in the 60s and 70s still detained in a high secure Waypoint. On the flip side as well, JP, and this is the last thing I'll say, but keep in mind that the system doesn't discriminate based on the gravity of the offense. So I have clients, one client has been consistently locked up, detained in hospital in a secure setting for 7 or 8 years. And his, what we call the index offense, so the criminal offense that brought him into criminal justice, he has an acquired brain injury from when he was young. His offense was stealing a bag of potato chips from the dollar store, and I think a small stick of deodorant. That was the offense about which he was found to lack criminal responsibility. And he's been in secure detention and custody for 8 years as a result of that. So there are a lot of people in the system who came in with very minor offending.
Yeah, and I can imagine sometimes the client might say, well, I don't want this finding. I'd rather just do like a 90-day or whatever, like 3-day jail sentence, and then I'm back out and not having to deal with the potential of an indefinite detention there, right? And I know maybe a good segue into the consent and capacity board and then some of the other tribunals work. So maybe you can tell us a little bit about how all that works, and you mentioned the review board as well. Some of the work that's outside of the criminal sphere that deals with some of the same clients that you've had and had for a number of years.
So that's a really important point that you make, actually, JP, is that the clients that I serve who come in through criminal justice, who've been charged and found to be not criminally responsible in criminal justice, the client base is the same client base that I've served throughout my career on the civil stream. So, what is the difference between who gets criminally charged and goes away forever versus someone who's brought to hospital just for, overnight or a couple of days? It's the same client population, and police have enormous power when they encounter someone in a serious mental health crisis. Under Section 17 of the Mental Health Act, they have the discretion whether they're going to take the person to hospital for an assessment or an examination, or if they're going to lay that criminal charge. So the frontline officer gets to decide sometimes, ultimately whether someone spends many years locked up or whether they're going to get a quick admission in the civil stream. Still, even civil commitments, so the Consent and Capacity Board is another administrative tribunal, and it hears actually 33 or 36 different kinds of applications, all kinds of stuff. I won't take you through all of them, but mostly it's what people have access to review when they're formed. So you'll hear people saying somebody was formed, or in the States they would call it somebody was sectioned. So I think we all know that there's sort of a 3-day assessment process. A Form 1, your doctor can do a Form 1 and send you to any general hospital that has a psychiatric ward for a psychiatric assessment. And then there are all these forms that can be signed. So a little known fact is you can also be held forever on a series of these forms that doctors just sign. And there's no mandatory review of your situation. except after the first 6+ months, and then once a year after that. So if you're too vulnerable to apply, you'll never get a hearing. It's a patient application driven process. But if you're together enough to ask for a hearing, then we do, legal aid does give us a ticket or certificate, those of us who are in panel to do this work, to go to a hearing and try and get the person out of the hospital. It's not much authority, but it's some, and there's a whole system of rights advice around it. So what happens is I'll get a call from one of these people whose job is to provide rights advice to a patient, and they'll say this person made an application to this board, and then I'll go and try and get them out and just try and show that the doctor hasn't proven that they're a real risk of harm to themselves or to others, or that they need to be in the hospital for any other reason. The other sort of major category that tribunal looks at is when people lose the ability to make their own decisions to refuse these powerful psychiatric medications or to manage their own money. Third biggest category, community treatment orders. And your listeners may not be aware that in Ontario, we have at least 10,000 people on these compulsory community treatment orders, which means, if you take regular daily medications, maybe for blood pressure or diabetes or for, acid reflux, imagine if you were taking that under pain of being detained if you didn't. So all these clients are out there having to take their psychiatric medications because if they miss one dose, if they fail to show up for an injection, police can go out, handcuff them, bring them into hospital and lock them up. So a lot of people with psychiatric histories are subject to these very coercive orders called community treatment orders. So those are also reviewed sort of once every 6 months in the civil side. Sorry, longer answer. I can talk forever about this stuff.
And what was the other? You mentioned the review board, right?
The review board is just the criminal code review board. In an attempt to fight stigma, the words criminal code were removed from it. And so now it's called the Ontario Review Board, which means nothing. But that's where annually that tribunal reviews the detention or supervision conditions of unfit and NCR accused. So there's an annual administrative tribunal system to review those folks. So really, I practice before the Consent and Capacity Board, Civil Mental Health, Ontario Review Board, Criminal Mental Health, Forensic Mental Health, and then coroner's inquests are the three major administrative tribunals.
Yeah, so let's go into coroner's inquest. Then you say you do some of that. What's that process like, and how does in terms of advising there and representing? What do you do in terms of the situations that come up there?
So I always feel really weird saying this. It's a weird thing to say, but of all the things that I do and have ever done in my career, including my Supreme Court work and all the sort of high glamour stuff, my favorite thing in the world to do, the thing that I'm happiest doing, is participating as counsel on these coroner's inquests. Now, always at the center of them is a tragic and usually preventable death. So they are incredibly emotionally taxing. There's a lot of vicarious trauma involved in a coroner's inquest process. For example, when it's a police killing, I have watched police shooting Michael Ellegon, hundreds of times in order to be able to cross-examine officers who were involved in that shooting. So it can be very traumatic. But at the end of the day, for me as counsel, so these are multi-party proceedings. So when the Office of the Chief Coroner calls an inquest, mandatory or discretionary call, there's inevitably going to be a lot of parties. So it's like a multi-party trial. There will usually be at least a dozen parties. There'll be lots of lawyers. And at the end of the day, there's a jury. So it really does feel and look like a trial. The presiding officer, though, is a doctor, is a medical doctor, coroner, usually. We now have some lawyers. There's been some amendments to the Coroner's Act where in some cases a lawyer may preside. And Selwyn Peters is now a presiding officer, which is great. I used to do lots of inquests with him as counsel. But it looks and feels like a trial. But, for me, a freeing aspect of it is that I don't have a client. There's not a person whose liberty is at stake. Someone has died. They're unfortunately already dead. And therefore, what I'm looking for out of the process is forward looking. It's preventative because the jury has the ability to make meaningful, practical recommendations for change. And I get really invested in that. I get invested in drawing the evidence out that will allow the jury to come up with ideas that might save lives in future with respect to avoiding similar death. And it's also a very collaborative process. Like, it won't work unless all the lawyers and all the parties ultimately come on side. So even if we start out as adversaries, we have got to start rowing in the same direction to make the process meaningful and valuable. And there's something really noble about the coroner's motto is "We speak for the dead to protect the living." And over 30 years of doing this work, I know there's a lot of cynicism around it because inquest recommendations upon inquest recommendations, build up dust on shelves and people feel like there's no change. But I have seen really meaningful change as a result of these recommendations in a lot of areas. And I get very emotional talking about it because these people died, and the only way that I can help to honor them and remember them is to try and make sure they didn't die in vain, and have something come out of these death inquiries that prevents the next, Michael Elegant or Andrew Loku or, any of these deaths.
Now, you mentioned again at the outset, that there, in terms of this area, in terms of mental disorders, there's not as much people practicing in the areas, and then for someone to, again, you can come into this, in a criminal matter, if you're a criminal practitioner, that one of your clients, may need to go through this process, and you may not be as equipped. Now we talked, obviously, you spoke at the CLA conference, but there's another organization that you brought off the ground there. Maybe you could tell us a bit about it and how that came to be, and what are some of the resources that they have to help practitioners in this regard.
Thank you, JP, so much for asking about that. So throughout my career, I've started at least 3 volunteer lawyer organizations. I think I'm getting to be known for this. And if anyone needs a volunteer lawyer organization organized, I think I can now start them within an hour or 2. I got everything figured out. It's really easy. And I encourage you to start one if you're interested. Maybe I'll make like a template, a checklist for how to do it. The one that you're asking about now is called Lambda. It's the Law and Mental Disorder Association. I started it in January of 2017, so I guess it's about 6.5 years old now. It has 225 members, which doesn't sound like a lot, but for people who specialize in mental health, mental disorder law, that is kind of a big number, because most people will come upon this field rarely in their practice. So all of our members have a significant percentage of their practice devoted to representing people with serious mental health issues, either civil or criminal. I was involved with a precursor organization that focused just on the consent and capacity board work. And then I was on the board of the Criminal Lawyers Association for 8 years. They had a little mental disorder committee that I think I might have also started. And then I just saw this sort of vision for, okay, why are the people in the criminal stream who have clients with mental health issues in this pocket, and the civil people are in that pocket, and Ontario's over here and Alberta's on their own? So Lambda is national. I wanted to create like an umbrella organization and bring all the members of the different organizations together and just have one big place, not to compete, but just to, consolidate gains and resources and work with all the existing, smaller organizations that had a sort of narrower focus. So we have 225 lawyers. We invite law students as well and articling students across the country. We are national. We have a robust list service that's very collegial, very friendly, very supportive. You can, people every day go on there and say, I have this hearing coming up. Can you send me cases? Has anyone seen this before? Because so many weird things happen in our area of law. And everybody helps out. Very collegial, very supportive. We share, factums and materials. We hold free CPD. And JP, you and I were talking before you got on the air. A lot of young lawyers and students can't afford even the $40, $60, $75 for regular CPDs. When I was a new lawyer, I certainly couldn't afford, $100. I remember filling out an application to try and get a subsidy to get my CPD hours. And so one of the things I wanted to do was put on free CPDs. So, we used to have monthly CPDs in person with Zoom, and through the pandemic, that was even easier, like you're doing here. So we would just have panels, our members are experts. We would get them to do education sessions. We would have conferences, in the past jointly with the CLA. We would have mental health check-ins during COVID. A lot of our members have very serious mental health and addictions issues and other problems. Our lawyer members, a disproportionately high percentage of our members are themselves experiencing some of the challenges that our clients have. And so we would have regular mental health check-ins, no judgment, no fear of reporting to the Law Society, and just, candidly checking in, which I think was a lifesaver for some of us during particularly the lockdowns and early part of COVID. But so that's what we do. We support each other with the work on behalf of the clients. We, help each other manage our clients who sometimes require a great lot of patience and energy and support from us, which can be very taxing. We're there for each other. And we also, we as an organization, we lobby for change. We make submissions. We're a trusted partner. We have made all kinds of submissions to various levels of government. We're a serious stakeholder, and we liaise with Legal Aid Ontario. We sit on stakeholder committees for the Court of Appeal, for the various tribunals, for the Consent and Capacity Board, and advocate in the interests of our clients and advocate in the interest of our lawyers. So I'm really proud of the organization. We haven't had one sort of, uncomfortable moment, no incidents in our interactions. So it can be done. And I think it's an important organization for our members. So I'm very proud of that.
I mean, one of the things you brought up there certainly is the mental health and wellness of lawyers and practitioners in this field, right? Whether you're doing social justice, mental health work, there's civil or criminal defense, and often on the defense side, you're kind of the people that are stirring the pot, and meanwhile on the government, the state actors are held in differing regard, and that in of itself causes the stress and anxiety, and then again being involved where a lot of your clients are going through these processes, and it takes a toll on you. And I know certainly we've done better over the last few years, but I think there may still be, as you said, having these wellness checks during the pandemic, that there a significant portion of our population as lawyers and practitioners, we're not dealing enough with what's going on there. Anything that you can share, again, whether from the perspective of Lambda or just your own perspective of what's going on here.
So that's a really great and complex question, JP. I'll tell you what, I've been thinking about writing up a lot of this over time, and I've got a million articles in the back of my head that I just need time to write up. But I was looking through the national study on lawyer mental health that was recently conducted. It's really important work. And then I try to do like control F, like a find for solo or sole practitioner or legal aid or small firm or something like that. I didn't see any particular sort of lens brought to bear on our group. So I think when you say progress has been made, I think yes, a lot of wonderful movement and progress has been made on lawyer wellness and mental health in the last few years, with Chief Justice George Strathy talking about his own mother and his own sort of thoughts about mental health, and talking about the gladiator syndrome, and that it is a crisis and we have to look after ourselves. With Beth Beatty, who you spoke to recently, who I did an inquest with in 2005 when I was very pregnant with my son, who's been very brave, opening up about her own experiences. We've got Orlando Da Silva, Aaron Durant, a lot of high-profile lawyers talking about their own mental health challenges. All of that is progress and helpful in dispelling stigma, and I commend them all for doing it. On the other hand, and at the same time, Law Society mental health programs, a lot of the programs focus on the situation of the bulk of the people that the profession sees people on Bay Street, people in big firms who have their own pressures, like their own pressures to bill a lot, so on, and people within government, in the Ministry of the Attorney General. So those the people under a particular kind of strain in those circumstances face very different challenges from the sole practitioner, the small firm lawyer, the private bar practitioner, particularly in criminal law or in mental health law, where in mental health law, 100% of my clients are legally aided. I don't have the luxury of mixing my practice with privately paying people who are very mentally unwell. And I'm 30 years at the bar. My private rate would be $500 to $600, perfectly acceptable, reasonable rate for 30 years at the bar. My legal aid rate is 100 and change. So I am getting paid 1/5 of what I would be if I were out there at my year of call. So as you can imagine, in order to make a living that I would otherwise be making for my family, I have to work 5 times as much. And so when people start talking about work-life balance to me, and why don't you go on more holidays? And Law Society says, take holidays and be careful, watch your mental health. Work-life balance is a bit of a myth when you have a purely legal aid practice, when you're practicing criminal law, and you have to take calls in the middle of the night when your clients are detained. And when your practice is a legal aid practice where you only, eat what you kill, and you've got to bring in the income as a volume of work where you're working all the time. So the stresses on our little bar are huge, and they are exacerbated by these sort of hourly microaggressions, I like to call them, where defense lawyers and mental health lawyers and people working for poor people in social justice, particularly for people who are mentally unwell, we simply don't get the respect that our colleagues who are Crown attorneys, who are hospital in-house counsel, who are state actors get in any litigation proceeding. I mean, it's not universal, but often we are seen as troublemakers. Why are you making so much trouble for the court or the tribunal? Why don't you just agree to this? Why are you taking so long? And we are seen as if there's a level playing field. So we get told to make written submissions, do everything that would help the system. Only we're not resourced for any of this stuff. And so unfortunately, that weighs on you. I'm pretty thick-skinned, and I don't really care what people think of me, but I don't think it's great that after 30 years, I can count on one hand the number of times a decision maker thanked me in particular for my submissions or my contributions, whereas when a psychiatrist testifies in my proceeding, they have never left the proceeding without being, profusely thanked for giving their time and their expertise and showing up as a witness, even if they were ordered to come. So we just don't get any of the respect that we're due on my side of the equation. And I think that really weighs on us in addition to the vicarious trauma. So I think we need to do better. We need to recognize the work that my bar is doing and start appreciating the unique and particular stresses that we're under, because we've got lawyers, during the pandemic, I got calls from my colleagues who had drunk a bottle of something by 10 a.m. And I think we're talking a different level of distress than what we're candidly acknowledging in these bigger groups. So, Rome is burning, and we need help.
And so where's the help coming from, or what can we be doing, specifically in this area, right? I mean, you've highlighted a number of people and a number of things that are happening more generally, but what are the kinds of supports? I mean, or is it something like, well, if legal aid's paying 1/5, I mean, there's something you can look at and addressing, even though it's not like politically like, hey, we want to put more money in legal aid because it's not going to get votes or something like that. But is there more to it than just starting there, or what else can you highlight?
I think we are now getting a better sense of, I think what isn't going to work is putting the yoga and banana obligation and work-life obligation on me. So telling lawyers, look after yourself better, exercise more, eat better, meditate. It's just more of a to-do list for me. It's not a personal responsibility problem. we need structural change. Everybody else in the system has to be mindful of what we're dealing with. So if we say, look, I need to zoom into this proceeding, I can't come there. Or if a young woman lawyer or a caregiver says, I have caregiving responsibilities, I can't start court till 9:30, I think we need to be mindful of that. So I think it's institutional flexibility. It's educating people that we need respect and accommodation too, that we're human beings as well, that we are representing clients, and that the administration of justice would actually cave in on itself without us. So, we do so much of the heavy lifting in the courtroom, so much of the preparation, the client care. We're sometimes the smartest and best prepared, often in the room. And so one of the things that bothers me is that 3,000 lawyers out of Ontario's 57,000 lawyers accept a legal aid certificate at all. And fewer of those have sort of predominantly or exclusively legal aid practices. And I really think that these lawyers deserve a medal. And we instead, I think the approach is, legal aid lawyers, criminal defense lawyers, mental health lawyers, we're treated like and I always feel bad saying this because I appreciate and truly respect gym teachers, but we're seen as the gym teachers of the universe, right? Like people think that we're doing this work because we couldn't get a respectable job. So the attitude is out there that we either couldn't make it on Bay Street, or we just didn't have good enough grades, or we're not good enough lawyers to be mergers and acquisitions litigators in one of the large firms. And I think people would be very surprised about our individual backgrounds in terms of how many of us choose to do the work that we do. So I think structurally, one of the solutions is, and when we surveyed women, we haven't talked about Wicked yet, but when we surveyed young women as to why they're leaving criminal defense as a mass exodus, their two biggest, the top number 1 and 2 issues raised were, one, the sort of unforgivably low legal aid rate. So yes, legal aid rates can stay what they are. And even with some proposed new changes, not good enough. We need to aim for some kind of parity with what crowns are making. So that's the number one thing. And the second thing is a profound disrespect for criminal defense lawyers, for legal aid lawyers, for social justice lawyers, and in particular for women in our bar. And that has to change. We simply have to be taken seriously, respected, and thanked for showing up under the circumstances that we suffer. That's the solution.
Now you brought it up, and I guess that was where we're going next, anyways. But let's tell me about Wicked. It's a great name, right? Great acronym there. So where did that come from? And certainly what you just pointed out, these mass exodus from the practice in those two particular areas. Maybe you can go more into that.
Thank you for commenting on the name. So I did come up with the name. I'm the queen of all acronyms. I'm really proud of the name. And some people don't like the name. They got very angry about it. But so I am super proud of Wicked. I have a lot of ideas. I have ideas all the time. I exhaust everyone with my ideas. And some of them, frankly, are terrible. Honestly, go nowhere. So many, die on the order paper. But some of them are winners. And Wicked, I think, is probably one of the very best ideas I've ever had. My main contribution to it, honestly, was the idea and the name. And after that, it has taken off on its own, really, through the efforts of Maya Shikari, for example, who you interviewed recently, who's a Wicked Wonder, as you know, and other women. So what is Wicked? Wicked, believe it or not, Wicked's been around only for 1.5 years. It was started in January of 2022. Wicked now has almost 500 members, all women and gender diverse criminal defense lawyers. It stands for Women in Canadian Criminal Defense, all across Canada, with very significant representation from all our provinces and territories. Similar to Lambda, it was built on the same template as Lambda. Honestly, the power of Google Groups and Google Forms, an hour or two to set it all up. One day in November of 2021, something finally there was a straw that broke this camel's back after, I put in a year as the director, women's director for the Criminal Lawyers Association. It was a really positive experience during COVID, where I met a lot of the women members, and we hosted these sort of Ask Me Anythings with leading women. I got to know a lot of the women. I heard about the problems that women in criminal defense were facing on the ground. And I heard that they were very serious. So women in criminal defense face challenges and complexities that our male colleagues do not face. We've surveyed WICID's members. There's significant sexual harassment in the workplace, sexual assault even, and significant gender bias in the way that all women in criminal defense are treated, but in particular, younger women, newer lawyers, racialized young women who are simply not getting the respect they deserve based on gender bias. And the criminal law is largely an old boys club. There's still, a lot of old white men at the top of the profession who've been around forever. And the face of the profession is thankfully changing. We've got tons of women coming in as new lawyers, young racialized women, but our statistics show that 5 to 10 years into the practice of criminal defense, they flee. As soon as they start having families, they become mothers. There's really no way for them to access supports, parental supports, and they leave. The disparate impact of underfunding, chronic underfunding of legal aid on women, they leave. So all of this really concerned me, and I wanted to create a room of our own for our women and gender diverse colleagues, and a safe place to communicate where women's speech is not chilled, where they're not afraid to, ask questions and make comments and worry about, being shouted down. I wanted a place where everybody would interact in a very nurturing and collegial and supportive way. And I wanted a separate space for that. And that's what we've created. So we have a very busy, extremely helpful listserv. It's nurturing, it's responsive. We wanted a place to celebrate successes of women without being told that, our egos were out of control. There's a real humility that goes along with being a lawyer that I think is a bit of a false humility. I think if you're an old white guy and you walk into a room and everybody naturally recognizes you as the lawyer who's going to be speaking in this very serious way, maybe you don't need to market yourself. You don't need to stand extra tall or make yourself seen or heard, but you're a young lawyer, you're in your 20s, you're racialized, you're a woman, you're being mistaken for the court reporter or for the accused. I think it should be encouraged that our members are seen and celebrated. They're doing good work, and people shouldn't be shamed for being out there and letting other people know what they're doing, and getting their name and their good work out there. So what we do is we celebrate our accomplishments. We celebrate the incredible talent of our women members through Maya Shikari's Find Your Niche series, which is hugely popular, where she profiles senior leaders of the bar and innovators and new rock stars coming up. So that's been really great. So we have a lot of CPD, we have a lot of support, and both Lambda and WICID, I think, are on the cusp of doing really important systemic advocacy work and intervening in some really important cases. I'm sorry, I could go on forever. I'll be quiet.
Oh, you can certainly elaborate there, but Maya, I had a student, an international student who was from India, and the first day of class, I go around and say, "Hi, why are you taking law?" Things like that, and they had said that they were interested in criminal law, but they couldn't do it back home, right? That they were a little afraid of, in terms of practicing criminal law, and so you were just telling about some of these big areas where people are leaving the profession. So for anyone who's interested in criminal law, who's in school, whether studying as a paralegal right now or in law school, I mean, what could you share with them in terms of what it's going to be like? And certainly I want you to be as candid as possible, because they they want to know before they make that leap into the career. What do they have kind of ahead of them, and what can the profession do? What can you do? What can Wicked do? What can anyone do there to better nurture and grow, as we were talking about?
Yeah, that's a really good question. And I think if you'd asked me a couple of months ago, I was feeling very dejected, very down in the dumps myself. And I thought, I've done everything I can. And yet there are these, there are these incidents there. We see the numbers of women leaving. We surveyed our members. Everyone who responded to the survey in the last 3 years has known between 1 and 10 women who have left the practice of criminal defense, and mostly to go over to the Crown. So there are some things that Wicked cannot solve. So we're not going to be able to get you the same amount of salary that your Crown counterpart gets. We're not going to be able to get pensions and disability benefits and vacations paid that your Crown counterpart gets. So those are some of the roadblocks we can't help with. What we are really actively looking at assisting with, though, is on the sexual harassment and sexual assault side. The sexual harassment that our members face is significant, and they're getting it from all angles. So they're getting it from their male defense colleagues, unfortunately. They're getting it from Crown prosecutors they interact with. They, occasionally, the decision maker will exhibit sexually harassing behavior or certainly gender bias. And also the clients. A lot of our clients have difficulty being represented by women or young women. So that is a reality. And part of what we can do is give you the tools to recognize when it's happening to you. What is sexual harassment in the workplace? What is unacceptable? What is gender bias that you can call out? How you draw boundaries around that you don't have to put up with that kind of abuse. So that's one thing we can do. Another thing we're looking at seriously doing it, because the biggest problem is all of this is unreported. So in criminal defense, women are terrified that it will be a career-ending move to call out their boss or counsel opposite, even to complain about the client to someone at the head of the firm for whom this is a money-making client. So one thing that I think Wicked is seriously looking at is how to bring those complaints forward in a way that the individual is not responsible for it and it, can't face backlash. And I look forward to working with Discrimination and Harassment Council of the Law Society of Ontario, which I think is a really important service. And actually, Jacqueline Horvath, who's our Law Society treasurer, has been really good. And so was Teresa Donnelly, who's another woman treasurer before her. Both have been really good with recognizing the concerns that women in criminal defense have. And I have really renewed hope with Neha Chugh and Anna Maria Najer, and with Gerald Chan as benchers. I think I've been, bothering them since the day they got sworn in, or even before that, since the day they've been elected. I've been bringing these issues to their attention. So there are some things we can't fix. We can't fix the men. They need to educate themselves or figure out a way to internalize so they can recognize the implicit gender bias with which they treat us. We're not going to fix them, but we can try and compel education. I'll look into that further. But what Wicked can do is provide the community where you can express your frustrations. It's not an easy road. I wish I could say that it's all addressed and it's not something you're going to face. You will face it. It will be difficult, but at least we're calling it out now. We're identifying it. We're speaking, out, and we have an organization that will support you, listen to you, believe you, and hopefully be able to take forward some of these concerns on your behalf organizationally, because I think that's the most important thing, to take the fear, the whistleblower fear away. Is we've got to provide protection so that it becomes an issue we're tackling together or on a systems level.
And you mentioned obviously being on the cusp and wanting to do more in terms of interventions, things like that with both organizations. So maybe you could tell us a little bit more there, kind of what to look forward to for anyone that may be listening, or you know, students that may be getting called. I think there was call ceremonies very recently who just may have gotten called, that you know, maybe they're thinking about, you know, they're articling in these areas, and now they may be looking to join either of the organizations. So maybe you could give us kind of a quick here's why you should join, and here's what's coming in the future.
Oh yeah, no, definitely come and join. Come, please join Lambda. Please join Wicked. Oh, one other contribution I personally make, which I'm very excited about, and people think is really weird, is I learned how to make link trees. I don't know if people know what a link tree is, but once I learned how to make a link tree, I made a link tree for Wicked, and then I made one for Lambda. Then I made one for myself, and then I started bothering my friends to make link trees for them. Now, no one's ever looked at my link tree. Like the other day, actually looked at the analytics. Wicked's link tree is like hugely popular. It's been like, you know, clicked on thousands of times, and it's got a click through rate of like 85% or something. And then I wanted to notify my subscribers through my link tree about something, maybe even this. And then I got the world's saddest message. They went, no subscribers yet. Like, I don't know how long I've had that link tree, but maybe I picked like olive green for mine. Maybe that was a mistake. I'll go back. But a link tree is actually a really cool thing. And Wicked's link tree is very popular. And Lambda's link tree is not as popular, but it's not so, you know, so much of a loser as my personal link tree. Anyway, go to the link trees. Because for Wicked, all the information is there, and for Lambda too, including the registration link. So it takes about 2 seconds to register. I think both organizations have a really bright future ahead as intervener organizations. Probably in the Supreme Court of Canada is probably where we will start interventions, funnily enough. I have a long history of acting for different intervener groups in the Supreme Court of Canada, and I know that people feel differently about the value added of these interventions, including on the court. Sometimes you hear it's not helpful, and other judges, I think, find that it's important. I can tell you that, you know, several of the interventions where I've been involved, the court has cited our submissions, and it has had impact. So both organizations, you have to build, you know, a history. You can't just wake up in the morning and say, I am a new organization and I would like to intervene as an interested party in Supreme Court litigation. But I think with Wicked, you know, having 5 or 6 years, Lambda with 5 or 6 years under its belt, and a couple of years for Wicked with everything we've done and the submissions we've made, we can now put together an intervener record. So high profile cases that affect women, women members of the law, women clients, you know, racialized women, anything to do with women or gender diverse individuals are cases that Wicked could seek to intervene on, and anything to do with mental health or mental disorder law that affects our clients. You know, we get asked to intervene, you know, once every month or two regularly, and so we're gonna start doing that soon. I'm very excited about that. So I think you'd have an opportunity to hopefully contribute to that, but also just to be part of a really vibrant community. I think surrounding yourself with community when you're a student, and we have lots of students who love being part of these organizations. We're very popular with students and new lawyers, particularly now that so much of our work is done online. I think having a community in your subject matter expertise is really helpful. So we welcome all law students, and articling students and new lawyers and everybody. So please join us.
Perfect. So, yeah, last couple questions here. I mean, I know we've covered quite a lot, and you know, an hour goes by really quickly. I was wondering if there's
Oh my
anything,
gosh.
you know, that we may have missed that you want to highlight here. I don't have anything that we've talked about, or maybe not have talked about, as we wrap up.
No, an hour did really go by fast. I think, you know, I think I just want to leave everyone who may tune in with first, okay, go to my link tree. But no, I guess if I have like any kind of legacy statement, I really encourage people to make their own lawyer or paralegal or law student volunteer organization. Everything I've done is completely free. So there's never been any fee charged for any of these 3 organizations that I've started. No fees charged for any of the events. And I'm telling you, you can do it on any as general or as specific a level as you want. So within an area of law or an area of practice, if you want to make it, for members, gender specific, or whatever it is, or a subspecialty, or really big, you want to go national, or you want to go North America. It doesn't matter. You can create your own community. If there's a community that you need that doesn't exist out there, you can create it. And you can, the other thing is, leadership is not rocket science. So, people sort of wonder how I managed to do all this stuff. I don't do much. I just know who to put in charge of what. You surround yourself with good people. You utilize their strengths to advantage. You ask them what they want to do and contribute. And people want to work and contribute. And it's fun. So you surround yourself by people you like who are competent and smart and hardworking, and you empower them to do it. You don't micromanage, you delegate, you empower, and you celebrate the contributions that people make. And then it just kind of snowballs. So I don't know where these 500 people came from for Wicked, but they continue to come all the time. And you can do the same thing. And this was just, there was no national organization of women in Canada who practice criminal defense. I don't know how I was the first to think of it, but as soon as I told anybody about it, everybody was like, I can't believe this doesn't exist. We must have this. Except some of the guys who thought it was a terrible idea. And I was segregating the women. But other than that, so I just say to you, if there's something where you say to yourself, I wish I could talk to other students, other colleagues who do this and get help, and I could just blow out an email and I'd get 10 helpful things back. Make a Google group, 10 minutes.
Perfect. So Anita, last question here, kind of continuing on with the advice there for anyone listening, any students, any newly licensed paralegals or lawyers, any final words of wisdom besides, going to your link tree so you don't get that message anymore, or I know starting an organization, anything you want to leave with our listeners?
Yeah, one last thing. If you keep asking me, do I have anything else? I will. It'll be like 9 o'clock, so I'll have something else. I guess, there's a bunny in my backyard, and if anyone's interested in that, very cute. I guess I would say, as you embark upon a profession as a lawyer, paralegal in the legal profession, you'll get a lot of advice about how you should behave and how you should talk and what professionalism looks like and what you need to wear and how to comb your hair. And all kinds of people will say all kinds of things to you. And I don't know if you can see what I'm wearing, every kind of thing. I've had, some men said to me, I don't understand the way you dress. I find it confusing. And I thought, who cares? So don't let anybody throw you, don't let anybody comment on your style or on your makeup or on your hair or your voice or whatever it is. Don't let people's gratuitous comments get to you. We each find our own voice. We each find our own style. We each have, what it takes to be successful and leaders within our profession. You got to where you got to on your own steam and on your own talent and on your own personhood. And don't ever let anybody make you feel less than. And if you're getting feedback and comments that are diminishing, that are gender-based, that are biased, that don't make you feel good, feel free to call them out, draw your boundaries, speak to someone, and just be exactly who you are in the most authentic way that you want to be. And that is the path to success, and also to feeling good about yourself at the end of the day, where you look in the mirror at the end of the day and you know that you've done everything in the way that you feel good about doing it and you feel is the right thing to do, and you're comfortable with the way you did whatever you did. That's all that matters. There's no point in trying to please other people, because people will try and shape you and cut you down to size. Everybody has their own ulterior motives. Took me way too long to figure all this out. So at 30 years, this is my gift to you. So now, having told you never listen to what anybody tells you, about how to do things. I've just told you what I think you should do and how you should do it. So feel free to ignore me.
Thanks so much, Anita, for taking the time and joining us here today. Wish you all the best, and thanks for everyone for tuning in. Take care, everyone.
Thank you so much, JP. It was really great time.